After that insightful session, our upcoming panel discussion is one of the most woke subjects being battled in the techno-legal arena today. With the advent of internet, where boundaries itself are transcended, cross-border transfer of personal data. I'm elated to introduce the moderator of the esteemed panel, bringing you this exchange of thoughts, Mr. Ganapathy Subramaniam. Mr. Subramaniam is the Information Security Director at UPS. Mr. Ganapathy Subramaniam is the Information Security Director for Europe, Indian subcontinent, Middle East, and Africa. His previous stints include him heading Information Security Wings at HRG, Flipkart, Microsoft India, PwC, and Accenture. He's an independent trustee of the Internet Watch Foundation. And on that note, the stage is yours, sir. We look forward to hearing you all and the esteemed panelists.
Yeah, thank you. It's a real pleasure to talk in this FD PPI event, and in particular, privacy. Privacy is a subject that's very close to my heart, and Mr. Navi has been a kind of a guru for many privacy professionals and cybersecurity law enthusiasts in this country. So it's a real privilege to talk in an event organized by him, and I'm also participating in an event in India after a gap of about close to 5 years. So I'm very delighted to have received this invitation, and it's a real honor for me to speak here. I wish to introduce my fellow speakers and the co-panelists in this session. First of all, Mr. Navi, he doesn't need any introduction. Everybody knows him as a sort of a privacy guru and a pioneer in cyber law, even well before everything came into existence here. So, right, his cyber law school was tutoring many of us in the country. So I'm not going to introduce Navi to you, right? It's like lecturing birds on flying. So I'm going to introduce Mr. Navi, and I will go on to Mr. Guna. Guna is a technocrat. Will somebody display that profile of Mr. Guna and share screen, please? Manju? Yeah. Mr. Guna is a technologist. He's based in Dubai, and he's a CTO, and he's going to talk about an excellent product that facilitates pseudonymization and facilitates cross-border transfer of data. He has led large technology teams in different countries, both in India and in Middle East, and he was also in Muscat for a long stint. And currently he's based in Dubai, and he'll throw open some of the organizational and technological measures that are required to protect data and that will enable a very secure cross-border transfer of data. Meena Lekhi is again sort of my neighbor. She's based in the UK as well. And she's a lawyer, but working in corporate world. She's an expert in GDPR and other privacy laws, but she also takes care of commercial law and corporate law requirements as part of her job requirements. So I've got an excellent panel. Possibly, it's very easy to ask questions rather than answer questions. So I've taken the most easy job in this panel, going to ask questions and try to share my perspective now and then as we continue our discussion. So how private individuals are we, right? That is the very first question I want to ask this group, right? Culturally, right? I hail from India, though I live and work in the UK now. Many of you know that I hail from India. I've been with you and I was born and brought up there for 30 years. So are we really a private individuals, right? Before we worry about cross-border transfer of data, are we really private individuals? Our wedding is a public ceremony. A funeral is a public ceremony. Our worship is a public ceremony, right? We are really not private individuals, right? Technically, privacy is more a Western concept that has been imported to India. I'm just sharing my individual perspective, right? 19th century judgment had a definition of privacy which said that privacy is a right of an individual to be left alone, right? We were never alone, right? Our grief we share in public, our joy we share in public. So in that scenario, right, how typically privacy is enshrined within every individual, right? Until the judgment came from the SC, making privacy as a fundamental right of individuals. How much can we connect to our privacy as an individual, right? I just want to throw open that question to the panel and then go on to cross-border transfer of data, sharing my perspective on that. So, Mr. Guna, are we a private individual?
Yeah, I strongly agree with you. And as far as the Indian culture is concerned, so we are more of a public individuals rather than private individuals. Most of the the events in our life is exposed to like family and friends and even third parties. So even now with the advent of social media and other things, it is getting more and more publicized than privatized. But still, as far as the privacy professionals, so we are strongly supporting the privacy and how to protect the privacy of the individuals and the data. So that is why we are here. Yeah, please.
Absolutely, absolutely. See, even you did good that you mentioned social media, right? People even post that, okay, I sneezed 3 times today, right? I coughed 4 times today, right? Even that is being posted, and there is a photograph of them sneezing or coughing you can see in Facebook. So to that extent, right, people are not really private. Okay, Meena, you are a very interesting personality to answer this question, right? With an Indian parentage and born and brought up in UK in the Western world, tell me your perspective.
Thanks, Ganpati. I agree with everything that you and Guna have touched on. Obviously I'm first generation British Indian, but my parents hail from India. So, I've been back and forth over, my life to date. And culturally, I agree. A lot of what we do is quite open, it has a community feel. But then having said that, having grown up in the Western world and educated here in the UK, the right to privacy is a fundamental right, and the right to a quiet life as well. So there's definitely a slight disconnect there, but an interesting one from a cultural perspective.
Yeah. Thank you, Meena. Now, Isa, would you like to share your view?
Unlike all of you, I am born in India and staying in India for such a long time. Unlike you, I have not even gone outside now for 5 years. So obviously, my viewpoint will be more Indian in that nature. In India, we have a culture where even when we introduce, people who know about Pravara, introduce myself, my father's name, and then my grandfather's name. Now our Aadhaar and PAN also has got my father's and grandfather's name. So the question of privacy is certainly what we have heard in the last few years only. Initially, of course, we spoke about health-related privacy because there was, and also financial privacy because they were directly having an impact on our existence, health, or say our money going out of the bank. Rest of the things like our personal habits and personal behavior, we have never actually considered it as really so important. In fact, that is the reason why in India, if we want to claim any compensation for privacy, I don't know how to actually value the privacy and convince a court that I have lost 10,000 rupees worth of privacy right or something like that. So I feel that it has been an uphill task for people like us to actually convince the Indian companies to educate their employees to respect privacy. That's why in implementation of privacy laws, the most toughest job is to convince the employees that privacy is important. But of course, I think after GDPR and other things, people are adopting to this, but definitely it's an uphill task.
Yeah, absolutely. I don't want to divert this discussion from cross-border transfer of data. Nevertheless, I just want to make a point to what you said, Mr. Navi. GDPR, typically everybody talks about fines, right? Everybody talks about 4%, 2%, 20 million, 10 million, all those stuff. But GDPR also has got Article 83, which talks about damages, right, to individuals. And there are very few limited case laws that have been given in the recent years, one in Austria, one in Germany, kind of stuff that I can remember, where individuals have been offered damages for any potential data breach of their data, but it is still not well established even in Europe, right? So with that point, let's talk about cross-border transfer of data, right? Why cross-border transfer of data is really important, right? It's not that it wasn't there since long. If you look at the 1995 EC directive, it still had cross-border transfer of data, right? Cross-border transfer of data related rules and restrictions. But binding corporate rules is a concept that was introduced in GDPR, which was not there previously, right? The previous 1995 directive talks more about the adequacy concept, right? Whether you are transferring your data to a country where the data protection rules and the other legal requirements are adequate enough to protect the human rights of the individuals, which is privacy. Because privacy is enshrined as a human right in the Western world. So the adequacy concept played a lot of role in the 1995 EC directive on data protection. Whereas when GDPR came into existence, it started expanding the cross-border data transfer requirements in terms of binding corporate rules and other mechanisms that are available to protect the data. Let's talk about 2 or 3 instances, right? Let's take Russia. Russia does not allow transfer of the data of its citizens outside Russia. China has got restrictions to make sure that the Chinese data is remaining only in China, and access to any law enforcement agencies of any other country comes with certain requirements, right? So these are just 2 examples which I can really quote, but there are again, one of the biggest eye-opener for Europe was the Snowden episode, right? Once the Snowden episode happened, everybody thought that, okay, US government is going to have access to every element of my life, and so that may cause a problem. So that caused some ripples. And then came the Schrems judgment. So, Meena, I'll start with you. What are the current challenges related to cross-border transfer of data, and what do you think are the mechanisms that are provided under the current law?
Thanks, Ganpathy. So I think if I take the second one first, in terms of the current mechanisms provided under the GDPR, and I think, some of those you've touched on already. So essentially, from a GDPR perspective, when we are looking to transfer the data of EU nationals outside of the EU, we can't do that unless, let me backtrack, to a third country that doesn't have equivalent data protection laws in place to the EU. We can't do that unless the recipient country has what's known as an adequacy decision, which you touched on, where essentially the EU Commission, after a thorough evaluation of the national laws, has concluded that a country's data protection laws are essentially equally as good as the GDPR, or other safeguards are in place, other appropriate safeguards. And again, you touched on some of these. So we've got the binding corporate rules, codes of conduct, certification schemes, or more commonly, what are known as the EU standard contractual clauses, which are essentially ready-made and easy-to-use model clauses drafted by the EU Commission, and essentially contractually bind the parties to comply with the requirements of EU data protection laws. So I'm sure most people on the call have heard of the EU SCCs. They've definitely been highly publicized in recent months. So taking the other part of your question in terms of the challenges, there's definitely been some noticeable developments over the last few years. And, we can touch on Schrems too, to start off with. Certainly Schrems was a game changer. Just in terms of background, back in July 2020, the Court of Justice of the European Union, in the case of the Data Protection Commissioner versus Facebook and Maximilian Schrems, invalidated the EU and US Privacy Shield, which was essentially a legal framework for regulating transatlantic exchanges of personal data for commercial purposes between the EU and the US. Essentially, Mr. Schrems, he's an activist, and he wasn't happy with Facebook transferring personal data to its headquarters in the US. He essentially argued that the data, both in transit and when it was stored in the US, could be accessed by US intelligence agencies. And this, according to Mr. Schrems, would be in violation of his GDPR rights. So one of the things that he also called into question was whether or not Facebook could use what are now known as the former EU SCCs to validate the transfer. His argument was that they couldn't, because it was invalid in the context of US transfers. luckily for us, the European courts decided they weren't invalid, but they did need some additional work. So
I'll come to you. We'll talk about it in greater detail in terms of the stuff, right? It's good stuff. But let me just go to Mr. Guna, actually, right? Do you think using technology, we can enable better cross-border transfer of data?
Of course. So, see, there are organizational and technical measures provided by, or set by the various laws, including GDPR. So, as long as one organization, when they are transferring the data to the other locations, if they practice certain, technical practices and certain tools and technologies, definitely there is a way of enhancing and reducing the risks associated with exposing the privacy aspect of the data that they are processing. So I'll come to you again. We'll talk more about the mechanisms kind of stuff. I'll go to Mr. Navi for a moment. What do you think are the cross-border transfer challenges? Right, you can talk about the Indian context in particular, some of the challenges what Indian companies or the IT service providers will have, and then we'll go to Meena to discuss about the mechanisms in terms of SECs, BDRs, and everything, and then I'll come to you on the organization technical controls. Yeah, Mr. Navi.
You already spoke about the differential, say, respect which their country and our country has on respect to privacy. So that is behind the scene for every Indian company when we take the work of processing. But technology-wise, we are a country which depends a lot on processing of data. So we would like to import data from outside the country and offer our services. So in this context, it is a responsibility both for us, the Indians, and the EU countries to actually work a sort of an arrangement by which privacy does not get infringed, but we will have some freedom in terms of the processing. So that via media, technology is what we are trying to find out. Now, in the year after the Schrems, now the expectation under adequacy, of course, I don't think India will ever get into the adequacy claim for some more time, at least in the foreseeable future. We will be working on the standard contractual clauses because India is still a country where security is a high priority. Security of the citizens. We are a terrorist-afflicted country. So privacy is subject to the exceptions which are there in the articles of the Constitution. So we are not having absolute privacy, whereas in EU, perhaps they have a very higher grade of privacy expectation. In India, legally also I can justify that there are reasonable exceptions, one of which is security. Because of that, the local enforcement agencies, law enforcement agencies would like to have their own rights, which was the one thing which was turned down in the Schrems agreement, judgment, against the US intelligence agencies. So in India, I don't think we will ever agree that law enforcement agencies will not have a right to access the data, except we can say it has to be done by a due process.
If I may interrupt you here, right?
Yeah.
Is the worry of citizens about foreign intelligence agencies accessing the data, or you mean to say that citizens of the country must accept access to their data by their own local law enforcement, and they must worry only about access to data by a foreign government? Do you think so?
This GDPR applies to data coming from EU. So as far as the ordinary Indian citizen is concerned, I should not be really worried about these data unless that data has some impact on Indians' security. That is, if there is a terrorist operation, some intelligence information is contained in the data transferred to India, and law enforcement wants to access that, there is a security concern as far as Indians are concerned. Otherwise, if it is a commercial data of an EU organization which is being processed by a commercial organization here, I am not concerned. So if we agree that we are talking of cross-border issues related to EU data, then Indian citizens partially may say that it's fine, you can do. In fact, our PDPP had a particular section 37, which said you can get yourself declared as an entity which is outside the Indian PDPP law. So that is one. Now, Indians' data being processed in India, of course, the Indians are concerned. Now, the problem with companies is they are mixing up the data and trying to apply only one law called GDPR and then say that I have to apply that in this context. So that is where if we can distinguish and say we will apply EU data to a particular section of our processing operations. And now if a law enforcement agency comes to me, I can tell this server has got Indian data, this server has got EU data. You tell me first whether what do you want in terms of your say investigation, then I can persuade him not to touch the EU data. But if he has got a legal authority to touch that EU data, I don't have the capacity to tell him no, because that is confronting the local law enforcement agency. I, as a CEO of my company, have to sit in jail if I confront that. So there is no such option available to the Indian processing agency to completely accept what the Schrems judgment said, unless you break the contract into processing of EU law separated and processing of Indian data separated. Today, if one company has got everything in one server and the police comes and says, I want to get information from your server, of course, sometimes they may say, I will seize. Sometimes they may say, no, I just want to have access. So, okay, then the question will be that you are violating your GDPR contract, which the local company may say, no, I'm not able to do, and then we'll have a clash. This is the kind of clash which was there with Twitter and other.
Yeah. See, I think access by law enforcement is a separate question, actually, because it is about why should my own law enforcement have access to my own data is a different question. Meena, some years back, there was this RIPPA, right? Regulatory Investigative Powers Act, which was in the UK. You remember that?
Yeah.
Which ultimately, it's still alive, but not as, energetic as it was when it was enacted.
Correct. Yeah, it dealt with things like covert surveillance and things like that by public authorities or certain other specialist authorities.
Absolutely.
But very, very tightly governed.
Absolutely. But do you think, Guna, having a technology control can ensure that secure transfer of data, can ensure better, better businesses for Indian companies, giving us sort of an assurance? What do you think? Can you achieve it using technology?
So basically, when we were expecting the Indian data protection law was, in the process, and we were hoping that will get introduced, and there are so many, processes within India. So whether they process for the Indian controllers or the foreign controllers, so they use certain processing systems, particularly when it is in the context of EU and GDPR, and the controllers are from these countries. So the existing processing systems, when they want to implement the additional technical controls, something like a pseudonymization, so they have to change their systems a lot. So we were working on, resolving that particular challenge without making any change to their existing system. Can we protect this data? So can we reduce the risk of, giving access to the raw personal data to all the, employees of the processing organization? See, one of the solutions we were trying to implement was a pseudonymization gateway, where, see, as far as the GDPR is concerned, the pseudonymization is going to come up with the two different result sets. One single data set will be converted into a pseudonymized one, plus an additional information which will have the key and configuration information. So this, in general context, it will be accessible by both controller and the processor. But the tool, the pseudonymization gateway, what it tries to achieve is, we will try to reduce the access or expose of the personal data to the processor itself. So that is where we got the advantage. By using this particular gateway, the controller can configure the complexity of the pseudonymization at individual identifier level prior to transferring the data to the processor. That is one context. Another context is if the from the Indian context, if the processor is getting data from some Indian controller as a voluntary or towards the Indian law, if they want to protect and implement their technical controls, they can still use the same gateway where the configuration and the key, all this information can be segregated and securely stored, and the rest of the employees will have access only to the pseudonymized data. Similarly, when we give back the process data to the client, be it European or Indian, we can give it back in the original format. So the tool, the gateway is going to help in reducing the risk by giving access to multiple people and segregating the key information to a secured environment. So this is the...
Okay. I'll come back to you again. Meena, you can clarify here. Anonymous data is outside the scope of GDPR, but pseudonymized data is within the scope of GDPR. Do you agree?
Yeah, I agree. So long as with anonymized data, it's truly anonymized. That I think is always the key pertinent point to check. But with obviously pseudonymized data, you still got a key of some sort somewhere that when sort of coupled with the additional information will be able to identify the data subject.
Yeah, okay. So in what way this pseudonymized option, because you're not taking the data outside the purview of GDPR, right? Even after the pseudonymized data, it is still falling under the purview of GDPR, right? The law enforcement agency of that particular country can seek for the key, right? It doesn't stop the law enforcement agency seeking the key. Yes, Mr. Navi, would you like to respond?
No, if the key information is not with me, the data processor in India, law enforcement can ask, I will say, I don't have that key. What I have is only pseudonymized information sent to me by my data controller. So I don't have the conversion key. So in fact, it is the same as sharing data on a need-to-know basis. See, if the data controller has pseudonymized the data at his end, and he is holding the identity mapping and sending me only the filtered data, which I am processing and sending him back so that he can reconvert it into an identified data. In India, the risk of local enforcement agencies asking for that information is only for the pseudonymized information. Now, as Meena was telling, that even anonymization is not 100% perfect. You can say pseudonymization, what if the table is stolen from the US, the other person? Yes, it is possible. But that goes beyond the corporate, you can say IT activity. If somebody wants to commit a crime and unearth some extra information, combine it with this and then re-identify it, we should recognize it as a crime and not burden the data processor that you ensure that nobody will ever steal this data, ever re-identify the data. We will do it up to a particular reasonable level. Now, between pseudonymization and anonymization, it is a layer of difference. Anonymization is more irreversible. Pseudonymization is, of course, reversible, provided you have the data, which, as Guna is telling, can be secured separately compared to the larger set of data which goes into the processing.
Yeah.
Okay.
Exactly. The GDPR actually talks about exposing this to the third party. For example, the pseudonymized data plus the additional information which has the key and configuration. They don't want to get it exposed to the third party. Rather, it is already available to both, the controller and the processor. So what we try to do is we limit that ability only with the controller and reduce the access to that additional information to the processor level itself. It makes much more safer for the controller and easier for the processor.
Yeah, provided it does not impede the business operations of the processor.
Correct.
Yeah, that is fundamental here.
That is the
right?
Technology part that
Yeah.
what people call as pseudonymization, sometimes they talk of de-identification, where they combine all identity parameters into one set, remove it, and give something else. That is not amenable for normal processing at the processor's store. Okay. What is talking of is we retain the characteristic of individual data elements so that your legacy processing software will simply process that software. It doesn't understand the difference, whether it is John or say somebody else, it doesn't understand. Some replacement, it will process. So the entire control is in the control of the security information, which in the ideal case, as an Indian processor, I will tell my data controller, please keep it with yourself. I don't want that at all. But in case he does not want to take that responsibility, I will have to create that gateway in my system, and a gateway manager will have to be created who will perhaps secure this mapping data so that my rest of the 1 lakh employees don't get exposed to the identified data. By that, the problems of cross-border data transfer, I think we should be substantially reduced. We are not saying that GDPR, this thing we can confront, because that is also a court decision. The data controller will not agree if I say that don't put this clause in SEC, this thing. He will say, this is what I will say, otherwise I will not give you the business. Indian companies, without going deep into it, are simply signing on the dotted line. But what I am saying is that there is an option for the Indian data importer to adopt this pseudonymization kind of a concept and then tell the data controller that your interest is protected, your SREMS, this thing is respected. So let us work on this. This is the concept of reducing the risk in cross-border and eliminating the cross-border risk in a totally different way. What you are saying about change of process will happen if I combine the name, some number, etc., into one set and then leave only the other data. Then my process will have to be changed and maybe it will not be able to do whatever it was earlier doing. So what we need to adopt is an innovative pseudonymization. And if it is done, then item by item, a data will remain the same. Instead of Ganapathy Subramaniam, somebody else's Gunasundaram's data may appear. So in case of data leakage or any such thing, the risk of infringement or the loss or harm to the data principle is very, very low. You can still say that if I know Ganapathy Subramaniam's information and I will understand that it is not Gunasundaram's and I will try to replace, then that is an extra knowledge which I should have. That becomes a criminal activity. I am bringing information from somewhere else and trying to change the data available with me and re-identify that. That is an unacceptable criminal activity for which law should punish based on the criminal laws. So that is what perhaps I think we are discussing here.
Okay, it's 12:21 for me local time. So I think we've got another 24 minutes. So I'll go to Meena, and then Navi, I want to come back to you in terms of this US executive order by Joe Biden, right? In terms of where there is a role of a civil liberties protection officer and a data protection court, which has been established in the US. I just want to talk to you to see whether India will be ready to have such mechanisms when the privacy law comes into existence. And I will also come, so Meena, let's talk about some of the SECs and the new SECs that are going to come into existence by December 27th, and what do you think will happen for companies? And you can also talk about the transfer impact assessment and the supplementary measures, what has been proposed post Schrems judgment.
Great, thanks, Ganpathy. So I think, yeah, two of the main developments following the Schrems judgment was the requirement to undertake a transfer impact assessment for any companies exporting data to a country that doesn't otherwise offer adequate safeguards that are equivalent to the EU GDPR, to really assess the laws and practices. Essentially, the concern is around surveillance agencies or authorities accessing data, and then that would be an infringement of the SCCs. So the TIA is really introduced to kind of safeguard that. And then the supplementary measures, if there are any deficiencies or gaps, are required to be put in place to bridge those gaps. And the detail really is sort of dealt with in guidance issued by the EDPB, sort of on the back end of the Schrems judgment. So outside of that, we had some development with the SCCs as well. Last year, we had a new sort of long-awaited version introduced, which kind of, they address, the compliance with the GDPR, but also some of the legal analysis following the Schrems case. So there's a transitional period for those clauses to be implemented. They took effect last year and on 27th of September 2021 for any new transfers. And then there was a grace period for any existing transfers to be updated with the new EU SCCs by the 27th of December this year. So at this time of year, if you haven't already done so, many organizations and businesses will be working hard to update their client and vendor contracts to make sure that the correct version is in place, as well as making sure that actually TIAs have been completed where appropriate. If the outcome of the assessment is that actually there are deficiencies in terms of safeguards, then it's important to make sure that those supplementary measures are in place. And I think as a panel, there's been a lot of discussion around what those sort of technical and organizational measures might look like in terms of encryption and pseudonymization.
Okay, thank you. I'll come back to you and discuss about this data notification challenges, data incident notification challenges surrounding cross-border transfer of data. But before that, I'll go to Mr. Navi and talk about this recent DOJ Act and the Cloud Act, or the presidential declaration in terms of the post-Schrems, right? In terms of the establishing of the Data Protection Court or the Civil Liberties Protection Officer. Do you think India is ready for that?
India is already in that kind of a regime. See, the problem in US was earlier they had proposed an ombudsman. The ombudsman was appointed by the president, was to be appointed or was under appointment from president.
You're talking about US, right?
US, in the US.
Go ahead.
And the court said that if the president as a political head is appointing that ombudsman, that is not adequate. Therefore, they struck down the earlier one. Now what they have done is they have tried to actually make it a little more independent judicial process. Okay. In India, if you look at the earlier Information Technology Act, we had this appellate tribunal. Now, even in the PDPB also, there will be an appellate tribunal. Now, the adjudicators officers are executive officers, but appellate tribunals in India are always managed by retired Supreme Court judge or High Court judge. So it is a judicial authority. So India earlier, even presently, the TDSAT, actually, which handles cyber law cases, it has got a retired Supreme Court judge heading the division. He may be appointed by government. Ultimately, the Chief Justice of India is also appointed by the government, but it is an independent judicial authority. So likewise, the new adjudication, appellate tribunal, which will be framed under the PDPB, whatever comes now, will also be a judicial authority. So we have the tradition of having judicial people in tribunals. So therefore, we don't have the kind of issue which was there in the US. we are already in that. And one point I want to mention is in the new EDPB guidelines, lot more responsibility has been thrown on the data controller. That is, he should satisfy himself that surveillance laws or in the data importers country don't impact or something like that. It is good for us, okay, because the responsibility is there. Earlier, it was not very specifically mentioned and there was a problem. Now, it is the complete responsibility of the data controller to ensure that he should know the transfer. That's what it says. No, controller should know the transfer.
Yeah.
Controller should verify the tool which is being used. So all responsibilities are there. Legally speaking, the direct question which you asked, India will have a judicial authority, which will be the second level. After appellate tribunal, it will go to the High Court or Supreme Court. So entire Indian judiciary will be there to satisfy or resolve any disputes. So I think this problem will not arise in India.
Okay. So, Meena, what do you think are the challenges surrounding notification in case of a data breach in the context of a cross-border data transfer, right? Notification has always been a problem, right? Between controllers and processors, this has always been a point of dispute, right? I've even seen situations where the controllers want the processors to report of suspected data breach. Forget about actual data breach, right? Controllers insist on suspected data breach. So now you tell me, in the event of cross-border data transfer happening, right? What are the notification challenges? And then I'll come to you, Mr. Guna, on again, how does your solution helps in case of a data breach notification requirement? Yeah. So Meena, go ahead.
Thanks, Ganpathy. Well, obviously, the privacy regulations will vary from country to country. In certain countries, the privacy laws will sort of stipulate a mandatory requirement on data exporters to notify the relevant supervisory authority or any affected data subjects about a breach or an incident. And in other instances, it might be voluntary, but the difficulty is that in those instances where it is mandatory, often there's a timeline attached to that. Under the GDPR, for example, it's 72 hours, which is it's quite stringent. So it's important, to make sure that within your transfer mechanism and or any sort of accompanying contractual sort of safeguards that there is a obligation on the importer to remediate the breach and sort of mitigate against any adverse consequences, but also promptly notify the data exporter so that any relevant notifications can be made in a timely fashion. So that the difficulty when it comes to suspected breaches, I mean, again, it really depends on the country-specific privacy law and ultimately a risk assessment, right? In terms of, is it high, medium, or low risk? What's the nature of the incident? Was it special categories of data? Was it large volumes of data subjects? Quite often, I think, in some instances, you might end up reporting to err on the side of caution. I think certainly my experience in the UK is that the ICO, so the UK Supervisory Authority, is literally quite swamped with incident notifications in terms of people erring on the side of caution. So I think it's always a case-by-case assessment.
Okay. Do you think how your pseudonymization solution, right? You proposed a pseudonymization as a solution for better cross-border transfer of data. How do you think your solution will help in case of incident notification?
See, our focus is on helping those controllers in using the technology to identify a given data set and doing this key and mapping information segregated and secured. Right now, we are not focusing on additional, privacy related features. Okay, so we are working towards building a roadmap of, to make this as a privacy suite and with support for multiple privacy laws. So currently our focus is on a gateway solution which helps the businesses to ease the process of the pseudonymization.
Okay. Do you think incident notification requirements of different countries, Navi, like 24-hour notification? India has got 6-hour notification, right? I'm not sure how many people can really meet those requirements, right? Will this, suppose some other country has got a 6-hour notification? Do you think it will be possible in case of a cross-border transfer of data?
No. Say a data processor has to only notify the data controller. So we are not connected to the regulator. Now, in India, whatever has been spoken of 6 hours in another context, let's say 2000, we are counting that 6 hours from the time when the company considers that a data breach has actually happened. Now, so once the company through that, what is the process they have got? It depends on the incident management system. Say reporting of a suspected data breach is one event. This 6 hours is not counted from there. Okay. There should be a process of some administrative, say, evaluation which confirms that yes, there is a data breach. From that time only 6 hours is counted. Therefore, this whether it is 6 hours or 72 hours, I think it is post identification of something as a data breach. Now, when you say suspected data breach, there are two things. One is whether the data breach has happened or not itself may be suspected, or breach has happened, but we don't know whether it is personal data breach or not, or whether it is the breach of a pseudonymized personal data or real data. Now, the pseudonymization actually reduces the risk there, because you have got an encrypted data which has been, let us say, leaked. We can say that what has been breached is encrypted data, therefore there is no harm caused to the individual. Therefore, the data breach notification itself may not be necessary. In certain laws, data breach notification is necessary only if there is a suspected harm. So, probably what Guna's this thing will do is that there itself it will attack the problem at the root level. Okay. So once that is taken care of, that has to be done by the incident management system. Incident management system should not say, when somebody sends me an email, I will start counting from that time and say an incident has happened. So in fact, the definition of incident in your incident management systems have to change. Okay, the word incident has to come at this next second level, not at the reporting level. Then this problem to some extent will be avoided. Indian certain guidelines, if you are talking of, which Mukesh will be talking later on, it is very clear that you have to define what is a security breach, and from that time 6 hours is to be counted. So incident definition is the key, and you should be able to justify it with the regulator. Tomorrow he will come and say, why do you say this is not an incident? I think it is an incident. So that justification should be by the policy. The company has to have a policy which will clearly say why I am not considering an anonymous report as an incident. Unless the anonymous report is a reliable report and I go and check and say that there is actually a breach, I will not even recognize it as incident breach. It is all in the pipeline. A reported incident, or it is to be incident, I have to put through a process and then call it as an incident.
Yeah, okay. We've got about 9 more minutes to conclude the session. So I'll go around the table, and then Meena, would you like to talk about your perspectives on cross-border data transfer in terms of how sometimes the rules are impeding the businesses, right, from actually achieving economies of scale or economies of operation? And what do you think should be there in the law? What is the ideal legal situation you would prefer?
I think in an ideal world, and I don't think this will ever happen, is for there to be consistency globally. Because I think one of the challenges, especially in a complex sort of processing chain, is that, because the privacy regulations will vary from country to country, you might have different requirements for what that valid transfer mechanism might look like. Say, for example, in the EU, we've got the updated new EU SCCs, but for the UK, We've now got what's known as the UK International Data Transfer Agreement / addendum. So, you know, if you're a business and you're transferring EU and UK data, you need to put two different forms of SCCs in place. And similarly, I think the requirements elsewhere vary as well. So in some instances, you might, for example, have to consult with the relevant supervisory authority, such as in South Africa, before you transfer personal data. In other instances, such as China, there's certain thresholds in place which restrict you from transferring, for example, you know, special category of data if it's over 10,000 data subjects. So it starts to get really, really complicated in those sort of complex processing chains. And China itself is currently in the process of issuing its own SCC. So, you know, where do you kind of draw the line? It starts to become really complicated. So I think, you know, consistency would be ideal, but I don't necessarily think that we're going to get that anytime soon.
Yeah, Mr. Guna, now, can any technical control enable, in your perspective, I know you are a fan and huge advocate of pseudonymization, but I would like you to talk about pseudonymization and any other technical control you think will enable better cross-border transfer of data, or is cross-border transfer of data related rules impeding businesses?
See, basically, when it comes to the engineering, product engineering part of it, be it product management also, the importance given to, you know, when anybody building a solution or a technology product or a solution, they give importance to the user experience of what is happening on the front end. But whereas what is happening on the system as such, what is the architecture, what are their architecture goals? See, broader perspective, one of the non-functional requirement would be security. So there, you know, there is the scope is limited to that particular security. Whereas when it comes to the privacy of the customer, right from putting up the privacy policy on the website and having the architecture designed based on privacy by design and following certain practices such as DevSecOps, which has got a lot of very good practices, which helps to enhance the privacy and data security, which the product is going to handle. So as long as the engineering teams and even the product design teams giving importance right from the beginning of the development or even the design, and then during the engineering process, if they bring in all this, you know, practices, and using, there is a site reliability engineering and observability principles and practices are coming. So whoever is actually giving importance to the data, particularly privacy of the data, you can look at the market, like people who value the data, they build better solutions and they get better revenue, and all those performances are really good. And if the focus is towards building such, you know, privacy by design, following privacy by design principles, and following this, you know, the practices like DevSecOps, definitely the engineering teams can build a better and secured and privacy-oriented systems, which can help in all respect, whether it is in-country or cross-border.
Yeah, but still, ultimately, the answer to the question remains as to whether you would allow a law enforcement of an alien country to access the data, right? Okay, Mr. Naqvi. In principle, right, law enforcement accessing any data, whether within the country or outside the country, is a debatable thing, right? So how do you think this cross-border transfer rules are really, are they choking the businesses, or you think they are necessary?
No, it is definitely.
What is the way forward?
Hurdles. No, it is definitely creating hurdles for business. So what we are talking of is a data exchange system. Okay, data controller wants to send the information, data importer wants to receive the information. There is this legal, say, interference, which these two commercial entities cannot fight with their own courts or their own governments. They have to go by what they are saying. So what we are talking of is a data exchange system which reduces, minimizes the risk. So this is a new kind of service, which is intermediary service, which will be required. And that intermediary service could be the one which is using the pseudonymization or anonymization or whatever else is there. Like in India, we were having something called consent manager kind of a thing. So if we can think of a intercontinental say data exchange system managed by independent organizations, okay, then it will be outside the influence of either countries. It will be like an independent entity. In fact, a framework for this was suggested by me 10 years back. We can rework on that. Basically, we are creating a body on which both countries actually place, like UNO. Today, UNO may be a kind of a thing which is 100 countries come together. Now, instead of talking about adequacy of my data protection laws, which should match with the other these things, now EU, EDPB and Indian Data Protection Authority can come together and agree that we will agree for an intermediary system which will be subject to the laws of both countries, and thereby we will relieve the business entities from this difficulties of managing this legal hurdle. Let them do their business. Let there be an expert, legally competent organization which takes care of the exchange of data in compliance with the laws. This is what I would like to suggest, and it can be worked out. Today, it may be only like an idea which I am giving here, but this idea can be made practical if there is a requirement, and I am confident that what Guna is suggesting is the first step. We will develop this later, for example, if the government of India wants. Okay, we can work on
Okay. Yeah, thank you. We've got 2 more minutes to conclude. I think it's a great session. We got a lawyer like Meena Lekhi and a technocrat like Guna and expert, cyber law expert and a privacy expert like Navi. I really enjoyed the session. I don't know how much the audience enjoyed and got out of the session, but personally, I really enjoyed the session and interacting and very intellectually stimulating discussions, etc. Right? Cross-border data transfer is always an issue, will remain an issue with various privacy laws, right? If you look at 2020, there were only about 15% of the countries had privacy laws, right? But 2023, you'll have at least 65 to 70% of the countries will have their own privacy law, right? Even the countries you never heard of, you would have never visited, have got privacy laws now, right? So to that extent, privacy is really growing. There is a wave of privacy regulations. So cross-border data transfer continues to remain as an issue. And I think every country should work to make sure that we are still a global village able to cater to everyone else. Thank you very much, Mr. Navi, for inviting me to this session. And I think we had a great session. Thank you very much.
Thank you. Actually, Mr. Nagendra Jawgal was supposed to be in the panel. Due to some medical emergency in his family, he had to withdraw and I had to come here. This is just for the information that why the panel was slightly modified. Okay.
Yeah.
Go ahead.
Thank you very much.
Thank you.
Thank you.
Thank you so much,
Thank you.
Thanks, everyone.
Thank you. Bye.
everyone.
Thank you so much, the esteemed panelists. It was a very informative session highlighting real-time and ground-level issues in the realm of different data protection regimes. Included some points on culture to understand the importance of privacy and data transfer, adequacy requirements, challenges that cross-border data transfer regimes face, technical concepts of anonymization, pseudonymization, and architectural goals of various organizations that are coming through in their product and business, role of public authorities, technology controls and segregation of data sets, bridging of gaps in the backdrop of the Schrems judgment, ombudsman and independent judicial authorities, issues pertaining to notifications as well as reporting. In the ideal world, of course, having a globally consistent regime, and powers outside of the countries accessing data. And, ending on the note with what Navi sir said regarding a global body like the United Nations Organization. Once again, thank you very much to the panelists, highly informative and insightful.